Good morning, everyone. Good morning. My name is Ashley Kim, and I'm introducing the next speakers on CMS's Medicaid home and community-based settings regulation, how we got here, and where we're headed. So we have two speakers. Chris Lowther is an associate in Covington and Burling's Employee Benefits and Executive Compensation Practice Group. His practice covers tax-qualified retirement plans, health and welfare plans, equity compensation, executive compensation, and individual retirement arrangements. He has advised on litigations, government investigations, and corporate transactions. And we have Phil Peisch. He's a co-founding partner of Brown and Peisch. He helps health plans, providers, state agencies, investors, and other clients navigate complex issues and disputes arising out of government-sponsored health programs. He has particular expertise regarding Medicaid, Medicare, the Children's Health Insurance Program, and the Affordable Care Act's regulation of private insurance. He also counsels technology companies and users on digital health issues, including with respect to the application of Medicaid and Medicare regulations to new technology, state regulation of telemedicine, and the certification and use of electronic health records. Prior to forming Brown and Peisch, Phil was a special counsel in and the vice chair of Covington and Burling's Healthcare Regulatory Practice Group. And another thing to note about Phil, he's actually one of the authors of the Covington legal memo on the settings rule, so you might actually be very familiar with Phil. So please help me, join me in welcoming Phil and Chris.
They're doing it remotely. Oh, gotcha. Well, thanks everyone for having us. It's a real pleasure to be here and to meet so many great folks working on these issues. A little disappointed to be following up Mayor and
Just adjust this for you. That was for the shorter people in the audience. Is that better?
Yeah.
Can everyone hear him?
Can you hear me okay? Okay, great. A little disappointed to be following Sister Rosemary and Mayor Emanuel, especially when we're going to start talking about federal regulations, but we will we'll do our best. So what we're going to do today is go through just a really high-level overview of some of the history of home and community-based services and the settings rule. We're gonna try to stay away from the weeds and really provide more of an overview, and I think we want to leave more time to hear from Melissa Harris at CMS, who I think many of you might be more interested in hearing from. But feel free to ask questions as we go through, and we're happy to answer any questions as we go along, or at the end, we're going to try to leave a few minutes at the end as well. So as you all know, Medicaid is the largest payer of long-term services and supports. And those long-term services and supports cover a broad spectrum of services. So the original long-term services and supports under the Medicaid statute were long-term care provided at hospitals, nursing facilities, and intermediate care facilities. Those have been covered for 50 years and were contemplated in the original Medicaid statute. Then in the early 80s, there was a movement to, and really before then, there was a movement to start covering long-term services and supports, not just in hospitals and nursing facilities and intermediate care facilities, but also for people who wanted to remain living in the community or live in other settings besides these traditional settings. And so Congress passed, oh wait, it's jumping around here.
Sorry, it's me jumping.
Okay.
Do you want that?
Yeah, I'll hold it. So Congress passed Section 1915C of the Social Security Act, which is in the Medicaid statute, to cover home and community-based services, home and community-based long-term services and supports. And this is the mechanism through which many people across the country receive home and community-based services. And it's both people with intellectual disabilities and people with physical disabilities. There's also various provisions of the Medicaid statute that have allowed states to cover through Medicaid other home and community-based services through their state Medicaid plan. So state Medicaid plan home and community-based services are different than the services offered through Section 1915, through Section 1915C, and states have less flexibility in what they can cover, in limits they can put around those services, and as a result, a lot of states tend to cover more of their services through these 1915C waivers. Okay, so just want to talk a little bit about 1915C and the key statutory provisions and limits. So first, to receive home and community-based services through 1915C, you must be evaluated to have the level of care that would be required to receive care in a hospital, a nursing facility, or intermediate care facility, but for the provision of these services that allow you to remain out of those types of facilities. 1915C waivers pay for the services only. It is not permissible to pay for residential costs associated with people who are receiving these services. So in many states, there are some state funding available for the residential costs, but the federal government does not share in those costs. Section 1915C waivers must also be cost effective. It means the state is required to show that the cost of providing the home and community-based services to individuals is equal to or less than the cost that would be borne if they were serving those individuals in a nursing facility, a hospital, or an intermediate care facility. States also have flexibility to not comply with traditional Medicaid rules in offering their Section 1915C services. So generally in Medicaid, if you're going to offer a Medicaid service, you have to offer it statewide, and you have to offer it to everybody for whom it is medically necessary. And you can't have waiting lists for services. That's the general rule in Medicaid. But in Section 1915C waivers, states are allowed to have exemptions to all those requirements. So states don't have to offer 1915C waivers statewide. They don't have to offer them to all Medicaid eligible populations, and they're allowed to have caps on enrollment in 1915C waivers. So in many of your states, you probably see, a waiver that serves 4,000 people, and there might be another 1,000 on the waiting list to receive services. And many of those people on waiting lists don't receive really any Medicaid-funded services while they're waiting, and those waiting lists can sometimes run, they can be years. People can wait on those waiting lists for years. As an aside, there are special Medicaid eligibility rules for people who receive 1915C services or who live in intermediate care facilities or nursing facilities. So some people on these waiver waiting lists are actually not eligible for any Medicaid services until they get into the waiver. So that creates significant challenges for families who are on these waiting lists, because not only are they not eligible for the home and community-based services, but they still might be waiting just for basic Medicaid eligibility and the basic Medicaid services that accompany that. And I just add, I think these limits on 1915C services are one of the reasons why you may see in your state that the overwhelming majority of home and community-based services are covered through 1915 waivers. As you know, home and community-based services can be, although they're generally much less expensive than nursing facility or intermediate care facility services, they are still increasingly large chunks of the Medicaid budget in a lot of states. And states have the tools to limit their costs under 1915C waivers by putting caps on enrollment, and limiting access to the service. So for a lot of states, the 1915C option for the last several decades has just been a much more appealing option from a financial perspective, as opposed to offering all these services through the state plan. So now I want to talk about the setting issue a little bit and how we got here. So individuals, again, as probably all of you know, individuals receiving Medicaid home and community-based services live in a range of settings. People live in their own apartments. They live in apartments with roommates. They live in group homes. They live in intentional communities. They live in campus settings like here at Misericordia. They live in family homes. They live with their parents. They live with a sibling. There's really a broad range of settings where people live. And before 2014, states had substantial flexibility in how they chose to regulate where people could live and not live and still receive these 1915C services. The statute has always prohibited people from receiving 1915C home and community-based services if they live in a nursing facility or intermediate care facility. But as long as someone wasn't living in one of those facilities, the states had flexibility to allow that individual to receive Medicaid-funded, federally funded 1915C services. So in 2014, CMS finalized what's called the settings regulation or the setting rule or settings rule. And it was part of a revamping of home and community-based services regulations, and it's found at 42 CFR 441-301. And I've put up here the basic language of what the settings rule requires. And the purpose of it is to ensure that everyone receiving 1915C services lives and receives services in a place that's integrated into the community. There are some additional requirements for settings that are provider-owned and controlled, and that really means any setting that's leased or owned or otherwise controlled by a provider. And things like privacy and sleeping units, including lockable doors, access to food at any time. Some of these requirements I know have created challenges for a lot of the settings where people live. There are exceptions permitted under the rules to these special requirements for provider-owned and controlled settings, but they have to be documented in the plan of care, and there's a process for doing that. A couple notes about the application of the settings rule. First is, it applies to everywhere someone receiving 1915C services lives or receives services. So with respect to the first place, where people live, it doesn't matter whether they receive services where they live. The regulation applies to any place a person receiving these services lives. Even if, for example, someone, let's say, is living in an apartment and the only home and community-based services they're receiving is they're going 4 days a week to a rehabilitation program a couple miles away. Their living environment is still subject to the settings regulation. And two, it does not apply to all. It applies to 1915C home and community-based services, and it applies to some other state plan home and community-based services, but it doesn't apply to, there are some state plan home and community-based services that the settings rule does not apply to, although they're limited in, I think in most of your states, there would only be limited home and community-based services that the rule wouldn't apply to. Okay. So the settings regulation also confirms, as has always been the case, that people cannot receive 1915C home and community-based services and live in a hospital, a nursing facility, or an IMD. An IMD is an institution of mental disease for mental diseases, which is usually like a psychiatric hospital or a psychiatric facility. And then there is a catch-all, and it also, the other type of setting that's not permitted is any other location that has the qualities of an institutional setting as determined by the secretary. The settings regulation also included a class of settings that would be subject to what's called heightened scrutiny. That's the second bullet here. And this is an area that I think has created, the heightened scrutiny area is an area that's created the most concern among families and providers, and has been the subject of extensive discussion with CMS and extensive debate. So there's a few different types of settings that are so let me back up. Heightened scrutiny means that in order for the setting to pass the rule, CMS has to determine through a heightened scrutiny process that the setting is sufficiently integrated in the community. And settings that are subject to this heightened scrutiny process fall into a few buckets. So I put one up here as any setting that is located in or on the grounds or adjacent to a facility providing inpatient services. So this could potentially apply to campus settings that provide the continuum of care. So if, for example, you have a campus setting like Misericordia, or any, it doesn't necessarily have to be the same size as Misericordia, but that let's say the setting has a hospital on its grounds or a nursing facility on its grounds, and then has group homes adjacent to that, to the grounds of where the hospital is, that would be presumed to, that would be subject to heightened scrutiny. The other, and I think arguably the most important bucket that's subject to heightened scrutiny is any other setting that has the effect of isolating. And that has the effect of isolating is obviously, subject to interpretation. But we'll talk, Chris will talk a little bit about how CMS, some guidance CMS has put out on interpreting that. But any setting that has that is determined to have the effect of isolating is going to go through this CMS heightened scrutiny process. And so before I turn it over to Chris to talk about that, I want to sort of flag, I think at a high level, what this does. So you have really a spectrum or continuum of long-term services and supports. You have, on the one hand, nursing facilities and intermediate care facilities. And those are, the settings regulation does nothing to them. Funding is still fully available under those, for those types of settings and for that type of care. And then on the other end, you have, let's say, someone living in their own apartment in the community. That's sort of one end of the setting spectrum. So you think about, you have all these settings in between. You might have intentional communities like Misericordia here, smaller, 2 or 3 group homes together in the middle. There's a whole spectrum. The settings rule ends up requiring that there are certain settings in that spectrum that don't meet the intermediate care facility standards or nursing facility standards. So they can't get funding and people can't receive Medicaid services living there, but they also don't meet the home and community-based services setting definition. And so it carves out a group of settings that are not going to be eligible for Medicaid funding. And I think that, I think everyone's still working through what that carve-out group of settings looks like, how big that will be, what the exact parameters are going to be, how many we're going to see that are actually lose the ability to have people living there who receive Medicaid home and community-based services. But there will be some. There's going to be some settings that fall into that piece on the continuum that are going to have to figure out whether to, either to get alternative sources of funding, or which is an enormous challenge, or make major changes, or shut down. And so I think that's one way to think about the impact of this. But again, I think how big a group that is still, and what the exact parameters are still in flux. And Chris We'll talk about the.
Before we move on to Chris, I just want you to know that there are question cards. I think they're on your table, right? So if you have any questions, just write them down and we'll pick it up and then we will do Q&A after they're done.
Yeah, and we're going to try to leave 20 minutes for Q&A, so I hope you have questions, because droning on about Medicaid regulations can put people to sleep.
All right. Yes, and I'll try and go quick here because I know we're running short on time. So before I sort of get into this, I just want to take a second to level set. I'm going to be talking about sub-regulatory guidance, which, you know, all sorts of agencies will issue informational documents, bulletins, things like that, you know, try to clarify regulations, because regulations can often be difficult to decipher, sometimes by accident, sometimes on purpose. That's why you need regulatory lawyers like Phil and I, thankfully. So what I'm talking about is sub-regulatory guidance, which doesn't have to go through the Administrative Procedures Act. So unlike the settings rule itself, there doesn't have to be a notice and comment period and a long, drawn-out rule-making period. So, you know, this sort of allows an agency, there are still processes they have to go through, which Melissa Harris, who was kind enough to come talk to us today from CMS, can tell you a little bit more about. There's still processes the agency has to go through, but you know, it doesn't quite have the same weight as regulatory actions. So one of the first pieces of guidance that was issued was a March 2014 letter that gave a little more detail about the sort of settings that are going to be presumed to be isolating for people. So it identified some characteristics such as places designed specifically for people with disabilities, or places where people primarily or exclusively are people with disabilities there and their staff. And then they also provided, this guidance also provided a list of residential settings that are typically going to have the effect of isolating people. So farmsteads or disability-specific farming communities. I'm sure many of you here in this audience are far more familiar with these settings than I am, so I won't go into a whole lot of detail there. Gated, secured communities for people with disabilities, residential schools, multiple settings that are co-located and operationally related. So these settings are all going to be subject to heightened scrutiny, so they'll have to go through both the state process, and then if they're able to get through the state process, they'll go to CMS for the heightened scrutiny test there. So the December 2014, more guidance came out, and I'm just going to highlight some of the things this guidance said. So one of the questions raised was, what about people who are already in rural communities who, you know, speaking as someone who grew up in a rural area, it's kind of hard to go to the broader community very easily. And the guidance said, no, they still have to have the same opportunity for community integration. It doesn't matter if, you know, they're already sort of naturally isolated by their geography. This guidance also specified that people have to have keys to their homes unless it's determined otherwise in the person-centered plan. So Phil talked a little bit about this. There are certainly places where you can have exceptions for certain individuals, but it's something that does have to be documented and reviewed. So it's not an easy thing to deal with. So interestingly, settings on the grounds that are adjacent to a private institution as opposed to public are not necessarily presumed to be institutions, but of course, CMS will be looking at their characteristics to see if that is the case. And then this guidance also said, although there are no express limits to the people who can live in a setting, that is certainly going to be something that's considered. So, you know, of course, a very large setting with a large amount of people, is probably going to raise more suspicion of being like an institution. June 2016, more guidance came out. Let me back up for just a second. So the settings rule, when it came out, it was going to apply, it had a 5-year transition period for existing settings to come into compliance. There's no grandfathering. You can't just say, well, I was around before this. But the rule did apply immediately to new construction. So one of the things that meant is that a lot of places that were sort of, planned construction was brought to a halt because there were concerns about whether or not the construction will be able to comply with the heightened scrutiny test or pass the heightened scrutiny test. So CMS said that no, we cannot pre-approve a setting based on construction plans or anything like that. CMS said that this is because we need to see many of the requirements in the settings rules about how the setting operates, so we need to be able to see what it's like operating. We can't just determine this based on construction plans itself. And I just covered that other bullet point right there about the transition period not being available for new places. And then once again, farmsteads and secured communities were identified as places that are going to be considered isolating from the broader community and are going to be subject to heightened scrutiny. So these are the actions that have been taken under the Trump administration so far. Most importantly, on May 9, 2017, CMS announced the transition period would be extended from 2019 to 2022. There's nothing, of course, stopping states who have already passed their transition plan from going forward. And I think there are some states that have actually, in fact, done that. And of course, the settings rule is still being applied to new constructions. And then as far as this last bullet here, we are expecting any day now new guidance from CMS on the settings rule, which we're all very eager to see. And that is about it. I think we've got about almost 10 minutes exactly for questions. Oh, okay.
Okay. I also wanted to let you know that I am reading some questions, and they're actually very state-specific. We cannot answer them, right?
We could try.
Are you sure?
Well,
Okay, because
I'm
I
not
know
sure.
that you're.
But
I
I probably
know
don't know.
sometimes there's conflict.
Yeah,
with
yeah. No,
state.
I mean, I'll. Yeah.
Okay. Well, not that far. Can you describe the extent to which states must defer to CMS's determination of whether a setting is sufficiently integrated into the community?
So that's a good question. So states are given the flexibility in the first instance to determine whether, whether heightened scrutiny is necessary or whether the setting just passes the regulation on its own. But when you get to the heightened scrutiny process, the regulation clearly gives CMS the decision-making authority on whether a setting passes heightened scrutiny. So it's not the state's decision, it's CMS's decision, just on the heightened scrutiny point. I would also say that even if you're not on the heightened scrutiny piece, CMS, if the state decides that a setting does not warrant heightened scrutiny and complies with the regulation without getting to heightened scrutiny, that is the state can make that decision. There's always a possibility that CMS will receive complaints from third parties about that setting. There are a lot of advocacy groups that are monitoring this and can raise concerns directly to CMS about certain settings that have passed the settings rule. Ultimately, CMS interprets its own regulations and guidance, and if it believes that a state is allowing home and community-based services claiming to occur at a place that CMS does not believe passes the rule, there's always a risk that the state could face like a disallowance action, for example. So ultimately, although the state makes a lot of the decision-making in this space, CMS has a lot of tools in its toolbox if it disagrees with the state's decision.
Okay. Next question. What is considered isolation for a setting?
I don't know. No, do you want to say that?
Yeah, sure. So, I mean, it's a good question, and because part of this, the guidance uses, broader community, and, I've, from talking to a lot of people, I mean, there's a stronger sense of community than where I live here. So, it's sort of this question of what are they being isolated from, although the guidance really says it's isolating them from people who are not receiving HCBS Medicaid funding. So, it's sort of looking at their ability to get into that, that community. And, and the guidance will say it's not just about, the occasional field trip. It's about, being able to kind of go out there, fairly frequently and being a part of, what's going on in that broader community.
I mean, just adding to that, that was sort of a glib joke, I think, but CMS has been pretty clear that isolating is defined by not having access, as Chris said, to people who are not receiving Medicaid, home and community-based services, and staff. So that's what they view as isolating. Anything where you're not being exposed to people who are not receiving Medicaid, home and community-based services, or are not providing them. I think, although I'm not sure this is in any guidance to date or the rule itself, I think CMS would agree, speculate a little bit here, that people are not, CMS does not expect people to be, to go into the community that if they don't want to. If it's a true choice, it's about opportunities for people to interact with individuals who do not receive Medicaid, home and community-based services. So if you're thinking about how to comply with the rule and make sure that your family members or the people you're serving are not isolated, I think opportunity is I don't think you should feel like you have to force people to go to the movie theater if they don't want to. It seems to be about opportunity more than anything else.
We have many questions, but we only have a few more minutes left. Oh, we got 15? Okay, that's good. So please explain the rules hierarchy: law, regulation, rule, guidance, opinion / interpretation.
Sure, yeah. So primary is law. So what has been passed by Congress, which is Section 1915C. So that's sort of where we start. And of course, legislation is passed through compromise. Well, it's not really passed very often these days, but it's passed through compromise, and it's sort of a difficult practice. So oftentimes legislation will be, once again, intentionally vague on points that they can't find agreement on, or maybe difficult political points. So they'll punt it to the regulating agency, in this case CMS, to sort of make some decisions, and then. So then from there, the regulation, or the next up is regulation, which is generally passed by the regulating agency after the rulemaking process, which is a fairly elaborate, involves notice and comment. People are able to write in. The agency has to respond to these comments or concerns that people raise. And then at the end, after various notices, they'll pass the final rulemaking, and then there's that regulation. And oftentimes the regulating agency will then have sort of, they'll be able to interpret things as they see fit under that regulation, which, without, if I bored you all so much, I'm not getting into Chevron deference for the lawyers in the crowd, but and then from regulations we get down into guidance itself, which will be various documents issued by regulating agencies. And once again, Melissa Harris, I think, can get a little more into the different type of guidance that's going to be issued. But some of the guidance is sort of goes through a more detailed process than others.
Yeah, and all regulations have to be consistent with statutes. So if you think of it as statute, regulation, guidance, all regulations have to be consistent with the statute. They can't be inconsistent with the statute. And then all guidance have to be consistent with both the regulation and the statute. But those are often very difficult legal questions when you often look at when you actually look at the text. And CMS, as the regulating agency, if it's ever litigated, they get deference in their decision that the regulation is consistent with the statute. And courts will defer to things that CMS does in regulation or in letter, sub-regulatory guidance, if it's not inconsistent with the statute.
Okay. So why are colleges, or I'm actually going to revise this, why are colleges or senior care facilities okay and not places like Misericordia?
So I'm not sure senior care facilities are okay.
I mean, like senior communities.
Yeah, so well, I mean, the straightforward answer is that, regular colleges and a lot of senior care communities don't receive, people living there don't necessarily receive Medicaid home and community-based services funding from the federal government, so they're not subject to this requirement. I think there's a real question about, we in this group have been focused on the impact of the regulation and how to comply with the regulation with respect to communities that serve individuals with intellectual disabilities. But there's a whole nother issue over here about individuals with physical disabilities and elderly people who receive 1915C services. I mean, Medicaid is a huge payer of services for seniors. And I think there's a real question about the extent to which, and I just don't know enough about how many senior care, how many sort of retirement communities have people with 1915C funding, or mostly people with 1915C funding. But if you had a retirement community, let's say of 200 people, and they were all receiving 1915C services, they would be facing the exact same problem Misericordia is facing. Or Misericordia is not, I hope not faced, but that a community like Misericordia is facing.
Yeah, I will say, and that actually has been a problem for those communities as well. A lot of the comments in the initial settings rule process was actually retirement centers who were raising concerns about the application of the rule to them. So it's certainly a problem for them.
Many agencies have been removed from the state's heightened scrutiny list. What steps can agencies take to be removed from this list?
So the best roadmaps for ensuring that you're not subject to heightened scrutiny are to look at the guidance documents that Chris went through. Those documents lay out some more specifics that CMS expects, that CMS is looking at in terms of determining whether, that CMS believes states should look at in determining whether a facility should be, or a community should be subject to heightened scrutiny. So if you look at those documents, I think they will provide some guidance, and you can work with your state. I mean, one of the things going on here is that you've got state regulators trying to interpret federal regulations, and they're trying to be safe. They don't want to find themselves in a situation in 5 years where they're facing a disallowance or some enforcement action from CMS. So when you're working with state regulators, it's important to, if you look at that CMS guidance and you think you've done things such that you shouldn't be on heightened scrutiny, it's important to use those documents in your discussions with state regulators and really talk to them about it and point at the documents to specific things you've done. I would say, as an overall piece of, advice, or I think maximizing people's opportunities to get out of the community, and I mean opportunities, not forcing people, opportunities, is probably one of the best ways you can try to avoid heightened scrutiny. So, if you, making sure that all community members are aware of their ability to use community transportation to go into town, their ability to, really do anything outside the community, I think is a really important step towards ensuring that you're trying to avoid the heightened scrutiny process. But there are some communities that I think it's going to be very challenging, short of additional CMS guidance, to avoid the heightened scrutiny process, and you're just going to have to go through it.
What is the next step for providers who operate in states that misinterpreted the regulations to the point that they have made their rules so rigid that it limits their ability to operate?
Well, I guess I'll point out, I mean, as one initial remark is that there's nothing preventing states from having more restrictive rules than what is set in the settings rule. The guidance is quite clear about that. As far as the misinterpretation piece.
Yeah, I guess, yeah. So I think step one is to figure out, if you think your state's rules are too rigid, step one is to figure out, why are they too rigid? Are they too rigid because the state made a policy decision that they wanted them to be more rigid than the settings rule? Or are they too rigid because the state misinterpreted CMS's guidance? If it's a policy reason, you're going to have to persuade them on policy grounds that it doesn't make sense to have rules that rigid. Bring state regulators to your communities. I mean, if it's a policy issue, that's the best thing you can do. Educate people, show them what your communities are like and all about. If it's a CMS, if it's a misinterpretation of the rule issue, then I think you have to do your best to sit down with the regulators and, pull out the guidance and the regulatory text and try to have a conversation with them about where they can loosen things and why.
All right, has CMS revoked funding for anyone, anywhere, for violating the settings rule? And number two, if a provider is in violation of rule and faces losing funding, why not just convert to ICF?
So I don't know of any yet. I've heard of one so it's revoking funding, I think that's the effect, but it's, they're not eligible to receive funding moving forward. I'm not personally familiar with any that have actually been denied to date. I have heard that there was one in North Dakota. I don't know if anyone here is from North Dakota or knows about that situation, but I've heard that, but I don't know about it personally.
I think one thing that we have heard of is projects that were in the works that had been halted as a result of the rule.
Yeah, and so as Chris said, projects in the works can't get pre-approval, so that's where you're seeing the immediate bigger impact is projects stopping or projects converting to private pay. I'm familiar with a project in Texas that was going to serve Medicaid, was going to accept Medicaid enrollees and converted to private pay because they didn't want to change their model. And the second question was of that was?
What was that?
Do you remember what the second was?
Why don't they just convert to ICF? Yeah.
Yeah, so that's an option. For a lot of settings that I'm familiar with, that's not an option they want to pursue because for I think a couple of reasons. One, becoming an ICF is a no small feat. That is there is enormous regulatory requirements around that, and it's a real move. And a lot of settings, that's not the point of them. They want to offer something that's not an ICF, doesn't feel like an ICF, is different than an ICF. It might not be an apartment in the community, but it's sort of something in between. And so converting to an ICF will guarantee their funding. Not only will it guarantee their funding, people can get in without a wait list. There's a lot of benefits to an ICF, but that might not be your mission.
Okay, so for some of the questions that have not been asked, don't worry because Melissa Harris will be speaking and we'll save those questions for her, okay? What would it take to revise or repeal the settings rule in order to create a better continuum of care and provide service in settings that have the best of community and ICF offerings?
So I think the original problem here, this is just my personal view, and this is the original problem here, I think, is not a CMS creation in that although there's money follows the person programs in Medicaid contemplates these sort of different buckets of funding for people receiving long-term services and supports. And CMS has to regulate those different avenues. I think to have a really good continuum of care approach to Medicaid funding where people have, and this is what I think would be most appropriate, just personally, where people can receive services in a continuum of spectrums and be eligible for Medicaid wherever they fall in that continuum of spectrums, you would need a statutory, you need to change them, you need to amend the Medicaid statute. And I mean, you could probably do a lot with regulations, but fundamentally I think the Medicaid statute needs to be amended, and that is an enormous challenge, but it's not, I don't think it's one that shouldn't be on the table and people shouldn't be working towards. I mean, there could be like a much better structure from a statutory perspective than just the bucket structure. But that's just my personal. And getting Congress to amend the Medicaid statute is like, I mean, in a meaningful, that's a big lift.
Okay. I think one of the questions about ICF presentation is when you refer to settings not permitted include ICFs, do you mean geriatric ICFs but not ICF DDs? You're talking about both ICFs.
So any setting that is an ICF, regardless of who the population it's targeting is subject, people living in that ICF cannot receive Medicaid-funded home and community-based services. So it would be both.
Well, thank you so much for your time and for flying all the way out here. Thank you.
Thank you, everyone.
And we'll be around all day, so if you had questions that didn't get asked, we're happy to chat. Come up to us, we'll be around.